Thank you.
To where it's from here, and then it goes straight back to here, like we had dealt with.
Right.
So I've hardwired it and used this as the.
Okay.
I think that's
working.
I think.
Okay.
So. I think.
Okay.
I've just seen too many clients that happen.
Ms. Devereaux, were you able to get
Yes.
connected?
Yes, I forgot to tell you with.
No, that's fine. We needed to take a break anyway. All right, let me go ahead and go on the record. Cheryl, are you ready? All right, the court will call 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. Ms. Rodriguez appears today with counsels Ms. Devereaux and Ms. Trujillo. Mr. Pralia and Mr. McCormick appear today for the state. We come on for day 4 of jury trial, and we are outside of the presence of the jury. Is there any issues that we need to address before we bring the jury back in from the defense?
Yes, please.
All right, go ahead, Ms. Devereaux.
Thank you. The first, Mr. Paralia kindly showed me a copy of his PowerPoint so that we can make these objections ahead of time. Are we good? Okay. The first objection, and just this is, I would say the first 2 is mostly for appellate purposes. I want to make these records. Slides number 7, 8, and 10 are autopsy photos of Mr. Dickerson. I would be objecting under 403. I am concerned that due to the very graphic nature of these pictures, having even frankly more than one in this case shown to the, especially in opening statements, is quite frankly unnecessary and highly prejudicial to Ms. Rodriguez. If the court recalls, this Mr. Dickerson's body is incredibly burnt. It's going to be very jarring for the jury to see a body in that state, although we did voir dire on that heavily. I still would object to the jury seeing 3 specifically in opening statements because, again, it's not necessary, and B, I think it's just going to be inciting.
And Ms. Devereaux, can you, so I can place that in context, I have a trial exhibit list, 7, 8, and 10. Do you know what numbers they are on the exhibits?
Mr. Pirelli will have to tell you on that one.
Okay.
Sorry.
All right. Ms. Devereaux, go ahead and continue.
So my concern is specifically for opening statements. I think it's going to elicit a lot of, he needs the, what exhibits 7, 8, and 10 are.
Slides 7, 8, and 10.
Yes, please. Thank you. My concern is that putting all 3 of these pictures, or frankly more than one, in a PowerPoint presentation, one of the first things we show this jury is going to be inciting quite a bit of emotions, sympathy, and bias against Ms. Rodriguez just from the beginning. Opening statements are not evidence, and so while I have no doubt that Mr. Perelia has a good faith basis that those will be coming in during the trial itself, I would be objecting under 403 for them being in his opening statement.
All right, thank you.
Can I take just a moment to get my autopsy folder for case law?
Sure, sure. Give us just a second, Ms. Devereaux. Was there a different issue that you also need to address?
There's two more, please.
Okay.
Put your buzzers on their side.
Thank you. And Mr. Praley, if you can, just so I have some frame of reference, the exhibit numbers to which those slides relate to.
149, 152, 164. If I could have a moment.
Sure. And then when you're ready, Mr. Praley, any response?
Yes, if I could just have a moment.
Sure.
So as it pertains to each of these exhibits, I want to provide the foundation first for the court. Myself, Mr. McCormick, and Mr. Burrows all met with Dr. Burson. We have previously provided the autopsy report as it pertains to that, which provides his findings and specifically discusses in that photos were taken to illustrate that. As it pertains to these three exhibits, I will note that Dr. Burson specifically discussed each of them within his findings, as well as that they demonstrate the condition of Mr. Dickerson at the time he was found, to include his face, to include his extremities. There's discussion of having to be identified through other methods. As to the specific internal injury that is discussed, I can tell the court that as part of his findings, he discusses that the carotid artery on stab wound number 5 on the left aspect of the neck with soft tissue hemorrhage is what's being depicted in that. On the internal photo, on the external photos, it's important because it shows the outline of the process, in that it appears on face value that Mr. Dickerson died of being burnt, when that's not the case. Upon further inspection, if the court looks at those other two exhibits, it zooms in on the neck where a piece of metal is found, and then the internal deals with the internal injuries, specifically noting that there are 5 separate and distinct stab wounds. So that's the foundation that the court should have. Again, it's left in the discretion of the trial court, and you have broad discretion. They're not unnecessarily inflammatory or prejudicial. These, again, have a probative value, and the probative value is not substantially outweighed by the danger of unfair prejudice. It's showing relevant facts as to the appearance of the victim, the location, the nature of the wounds, and other details that the witness will have to describe. That's consistent with People v. White, 199, Colorado 82. It's a 1980 case. And People v. Villalobos, 159, Pacific 3rd, 623. In terms of the gruesome or graphic nature, even if the photos are graphic or gruesome, case law says that they still may be admissible and still dealing with their probative value if it outweighs their prejudicial effect. For example, in People v. Ellis, the court found that photographs of internal organs or internal wounds were probative because of the facts in the case. They relate to the coroner's testimony as to the wounds depicted and the injuries noted, the cause of death, the manner of death. People v. Dunlap is a case example. That's 975 Pacific 2nd, 723, which specifically deals with the fact that photographs may be used to graphically portray relevant details, such as the scene of the crime, the condition of the deceased. The court can also look at 10th Circuit federal cases, United States v. Naranjo. That's 710 F2D 1465. In that, they talk about, even though autopsy photos by their very nature are, of course, to some disturbing, as would be expected in a case. In that case, the victim was shot, but gruesomeness alone does not make photos inadmissible. It talks about, in our court system, juries are entrusted with the weighty obligation to find the facts in criminal cases of grave importance, such as the one before us. It's incompatible that degree of trust to attempt to, quote, protect them from evidence questioned in the case. It was part of the surroundings of the scene of the crime. It was not unduly or graphic or inflammatory, and therefore the jury's not improperly tainted with. It says that even though photos are not pretty or even hard to look at for the hardened eye, that does not mean that they're not relevant evidence. There's a lot of case law dealing that relevant evidence is inherently prejudicial. It's only that when you have unfair prejudice and substantially outweighed probative value, which permits the exclusion of the relevant matter under Rule 403. Unless trials are to be conducted on scenarios or unreal facts tailored and sanitized for the occasion, the application of Rule 403 must be cautious and sparing. Its major function is limited to excluding matters of scant or cumulative probative force dragged in by the heels for the sake of the prejudicial effect. And again, that's People v. Naranjo. I think the court should also be instructed as to another case, United States v. Oldman. It's 979 F. 3rd 1234. Interesting in reading that case, you have the same coroner of Dr. Burson being dealt with here, and specifically when it comes to his autopsy photos and his depiction of illustrating what was in his report. The court found that they did not err in admitting the photos because he analyzed the photos, conducted the autopsy, dealt with what injuries he sustained before his death and after his death, and that's the very situation we have here. And there in that case, they continually say that we have held that district courts have the discretion to admit graphic photos that are probative, aid in illustrating the testimony of the pathologist, and specific for findings of facts where you have before and after. If the court has specific questions, I can provide more case law.
I do not have a specific question. So noting the defense has conceded that the state has a good faith basis to believe that this evidence will be admitted at trial, insofar as the objection is specifically to including those images during the state's opening statement, I am going to overrule that objection. I'm not aware of any support for the proposition that there is some separate and inherent prejudice associated with opening statements specifically that would apply to this issue. And it is unfortunate when we have gruesome allegations, it is almost necessary that there is going to be gruesome evidence associated with those allegations. So I will overrule the defendant's objection. Ms. Devereaux, you said that you had a couple other issues to address.
Yes, Your Honor. One of which is Mr. Perelia has on his PowerPoint on slides 60 and 61, essentially their Facebook messages between Ms. Rodriguez and her brother. I don't know what exhibit Mr. Perelia has them labeled under. If you could provide that, that would be helpful.
203 it's going to be.
203.
We've just added it. And I sent it to defense, but it did not have a number.
Okay, this is the same one.
Correct.
Okay. So, Your Honor, it's a a Facebook message between Ms. Rodriguez and her brother, Ernesto Rodriguez. I would object because I don't believe they have a good faith basis that is going to be admitted. Mr. Ernesto Rodriguez has not been a witness that they haven't advised us that is going to be called in. He's not on their witness list. And I would be objecting to his statements.
And this is between Ms. Rodriguez and her brother?
Yes.
Okay.
Under hearsay. Furthermore, as it is portrayed in the PowerPoint presentation Mr. Perelia has, it's essentially screenshots of a portion of the conversation and only Ms. Rodriguez's, and it's only a few words. So it's very misleading, and so I'd be objecting under 401 and 403 because they're not giving the jury the entire context of the conversation, nor are they giving the before and after correspondence with Mr. Rodriguez. They are also not, again, I only had a brief couple of seconds to look at his PowerPoint, but my concern is they're also, I don't believe, full sentences of Ms. Rodriguez, so they're not fully explaining what she had to say. And so I'd be objecting under 401 and 403. Sorry, I'm not sure if Mr. Perelia has anything to say to that before I move on to the next issue.
Mr. Perelia, I don't have Exhibit 203 in the packet that I have. Do you have a copy of that I can look at? Or if you can email a digital copy, that's fine too, just so I can look at that.
Can I see it, Vicky? Thank you.
And Mr. Praley, is this whole thing on your slide or just a part of it? And if it's just part, can you kind of point me to which part?
Sure. The whole thing is not on there. The portion that was on the PowerPoint is at 10:30 at 04:14:58 UTC. The defendant is the author, and she writes, "I think that thing I did is getting to me now." The next portion that is on there is her writing 2021. It's going to be the next at 10:30, 4:15, 10, like the guilt and regret. And then below that, and she says, I can't even talk to know about it. I can tell the court that in her Facebook records, number one, that we had noted to the defense and properly filed in People's Motion M, the notice of regularly conducted activity pursuant to 902.11. On that list, Ms. Rodriguez's Facebook was G22-04825. That was listed as number 9. An attestation was given pursuant to People v. Quillen. The people then would burn the entire disc. That would be People's Exhibit 194, and then the actual statements and the 4 pages that the court's holding would then be admitted in their entirety. I don't think it's improper to talk about portions of evidence in opening. Obviously, the defense is able to, in the course of testimony, object to this. I don't know what the foundation would be, seeing that they're 902.11, but saying that they were taken out of context in opening, that can be cross-examination, all those types of things.
All right, thank you. Insofar as the objection is to the fact that only a portion of Exhibit 203 is going to be displayed in the state's PowerPoint, I am going to overrule that objection. Mr. Braley, I'll leave this up here for you to grab at an appropriate time. And Ms. Devereaux, can you give me the next issue?
Sure, Your Honor. The prosecution has in its PowerPoint on slide number 74, and I believe it's a picture of what appears to be alleged by the prosecution to be Ms. Rodriguez's writing to Ms. Varela on a piece of toilet paper. I'm not sure if Mr. Aprilia has his exhibit number handy for that.
It'll be 204.
204.
204, okay.
Your Honor, this is a really big concern for a Rule 16 violation, specifically Rule 16 under specifically 3B1, the prosecutor's performance of obligations, which includes the discovery of any statements written by the accused shall be discovered as soon as practical, but no later than 21 days after the first appearance. The letter on this piece of toilet paper, we've never been discovered. And I can tell the court that we have a supplemental report dated it's written on June 9th by Detective Burrows, and it reads, quote, on June 9th, 2022 at approximately 11:42 a.m., Michael Hodgkin, Hodgin, an investigator with Hosanna Varela's legal team, provided me with the physical letters from Hosanna Varela.
And what was the date of that again, Ms. Devereaux?
June 9th, 2022.
Okay.
I took pictures of those letters, which were uploaded into digital evidence at the Greeley Police Department. There appeared to be one new physical letter than, I think he means that, was sent to the PDF photocopied version of the letters. The PDF document containing the letters was also uploaded into evidence. The physical letters were uploaded into evidence. Nothing further to add. Please forward this report to the district attorney's office. That is supplement 114. For our discovery, it came on what the DA's office has labeled Bates stamp 3,928. We have never gotten a photograph of this toilet paper letter before. We have not gotten a photocopy of this toilet paper letter before. We have simply never been discovered this. When I talked to Mr. Perelia off the record, he said something along the lines of, yes, you did. It was in one of Mr. Burroughs' summaries, too. We did not get such a summary. The only thing we've ever gotten from Mr. Burroughs in the DA's office in terms of a summary of one of Ms. Rodriguez's letters was the jail letter that they took from her cell that we've previously litigated. He included that letter, and we litigated that issue. But we have never received any discovery of anything Ms. Varela's legal team gave to the prosecution during their proffer.
And to make sure that I understand, so if I'm understanding you correctly, Ms. Devereaux, you received the report talking about it, but you didn't receive like a photograph of the letter itself?
Or no, what we have, the only information we have is what I read to the court.
Okay.
So there's not even like a description of what this letter said.
Okay, but you did receive that roughly in 2022?
Yes.
Okay, that was my question.
Yes.
Mr. Pereira?
Judge, thank you.
Or Mr. McCormick, go ahead.
I would disagree with the recitation provided by counsel. I can tell the court that this note that is being referenced is on Bates Discovery page 3454. I can further tell the court that it was included in a packet of information that was discovered to the defense on July 15th of 2022, September 30th of 2022. Ms. Trujillo downloaded it on March 22nd of 2024. There's been numerous downloads as well, July 16th of 2022, July 18th of 2022. Both counsel had it downloaded on March 19th of 2023. That included a number of items, including supplementals from Detective Burroughs of 112, 113, 114, and 115, and it also specifically included letters, jail notes and letters collected. So we've met our our obligations. There is no discovery violation under Rule 16.
And Your Honor, if I could just jump in, I did find it in discovery just now. The issue to modify that is it's essentially copied, but there's no indication, like it's a photocopy, but there's no indication that it was written on a toilet paper. So there's nothing, it's not a picture of it. It's literally just, I'm not sure if the court can even see it, it's just a photocopy. And I think the inherent fact that it is on a piece of toilet paper apparently is going to be used by the prosecution to verify that A, that it is Mr. Rodriguez who sent it, and B, how it was sent, because it was sent allegedly through the jail.
We also gave a photo of it, Judge.
Okay, I don't know where that is. We can talk about it off record, and I can withdraw my objection for now and re-raise it later, but I don't see a picture of it.
And Mr. Pereira, is the thing itself and the physical evidence at the...
Yes, to even go back, Ms. Varela makes a proffer. She discusses this specific letter and the language contained in it. And then Mr. Burroughs describes receiving it, and then it's actually booked in as a physical exhibit. And I know defense has viewed all the physical evidence, but I think the tag number is G22-12298, which is SUP 113 photos, which deal with the letters. Specifically, the image is IMG 3931.
Okay. Insofar as it's an objection to the opening statement PowerPoint, I'm going to overrule that objection. Ms. Devereaux, I'll give you leave to re-raise
you.
anything once it's offered for admission.
Thank you.
Ms. Devereaux, anything else before we begin?
No, thank you.
Anything from the state?
I just need to set everything back up.
All right, just let me know when you're ready and we'll go ahead and bring the jury in.
One final thing, Your Honor. I have been asked by the family as well as the media that's present in the courtroom that during a portion they would have to, well, it's the family's request to leave for a portion, and therefore I wanted to put that on the court's radar that there will be a pause for a moment, but then I'll proceed.
Do you have you informed your victim witness assistant of approximately?
Yes.
Give her some heads up so she knows when that is coming?
Yes.
Okay. I'd prefer not to take a pause if we don't have to, but if we do, we will. But if your victim assistant can just notify the family that it's coming soon so that they can just get up and leave discreetly without us having to take a pause, that would be my preference.
Understood.
And I assume you know generally how you're proceeding in an opening statement, so
Right.
it seems like that should be something you can accomplish.
Your Honor, my concern is that it's going to be, there's, just for the record, 4 individuals of this family who are going to be standing up and all leaving and entering at the exact time these autopsy pictures are shown.
Well, that's exactly what I just said. So I will expect that the state inform their victim witness person that they know when it's about to happen so that it doesn't happen at that exact time and we don't have to take a pause. I think it's reasonable for them to be able to say it's going to happen in 20 or 25 seconds so that they can make their way out discreetly.
Appears to be working, Your Honor.
Okay. Are we ready to bring the jury in so we can get started?
The people are.
Okay. And from the defense?
Yes, thank you.
All right. Thank you. And you all can be seated as you file. Thank you. All right, thank you. Please be seated. Thank you. Ladies and gentlemen, before we begin the trial, I want to describe to you what will be happening over the course of the trial. Excuse me. The first step in the trial will be the opening statements. The attorneys may make opening statements if they choose to do so. Ms. Rodriguez's attorney may reserve opening statement until later in the trial, or they may decide not to make an opening statement at all. An opening statement is not evidence. Its purpose is to give you a framework to help you understand the evidence as it is presented. Next, the prosecution will offer evidence. Evidence is what the witnesses say under oath and items allowed as exhibits. After the prosecution's evidence, the defense may present evidence but is not required to do so. I want to remind you that the defendant is presumed to be innocent. The prosecution must prove the defendant guilty beyond a reasonable doubt. The defendant does not have to prove their innocence or call any witnesses or introduce any evidence. After the evidence has been presented, I will tell you the rules of law which you must use in reaching your verdict. These rules of law are called jury instructions. I will read them to you, and you will be allowed to take them with you to the jury room during your deliberations. It is my job to decide what rules of law apply to the case. You must follow all of the rules as I explain them to you. You cannot follow some and ignore others. Even if you disagree or do not understand the reasons for some of the rules, you must follow them. You will then apply these rules to the facts you have determined from the evidence. In this way, you will decide whether the prosecution has proven the guilt of the defendant beyond a reasonable doubt. After you have heard all of the evidence and the jury instructions, the prosecution and the defense may make their closing arguments. Because the prosecution has the burden of proof, it will have the opportunity to reply to any closing argument made by the defense. Like opening statements, closing arguments are not evidence. Their purpose is to remind you of the evidence that was presented during the trial and to argue why you should return a verdict of either not guilty or guilty. After the closing argument, you will then go to the jury room to deliberate on a verdict. Your role as jurors is to decide what the facts are, and your decision must be based only on the evidence that was presented during the trial. At times during the trial, the attorneys may make objections. This means that the attorney is asking me to decide a particular legal issue. It is proper for an attorney to object to things which he or she believes should not be presented as evidence. When an objection is made, I have two choices. I can disagree and overrule the objection, or I can agree and sustain the objection. Do not concern yourselves with the reasons for my decisions about any objections. You must not let yourself be influenced in any way by the objections or my rulings on the objections. If I overrule an objection to a question, the witness may answer. If I sustain an objection to a question, the witness may not answer. You must not consider the question for any purpose or guess how the witness might have answered. If I overrule an objection to an exhibit, it will be allowed into evidence, and if I sustain an objection to an exhibit, it will not be allowed into evidence, and you must not consider it for any purpose. At times, I may instruct you to disregard statements you have already heard or things you have already seen. You must treat them as if you had never heard them or seen them. You must not consider them for any purpose. During the trial, I may need to talk with the attorneys out of your hearing about questions of law. Sometimes you may be asked to leave the courtroom or wait in the jury room while we discuss these things. I will try to limit these interruptions as much as possible. As a judge, I do not have any opinions either for or against anyone involved in this case, and you must not think that I do based on any rulings that I make or anything that I say or do during this trial. You have received juror notebooks. You may use these notebooks to take notes during the trial. However, you are not required to do so. If you take notes, you should not allow the note-taking to detract from your close attention to the testimony and conduct of each witness and all other evidence received during the trial. Whether or not you take notes, you should rely on your memory as much as possible. The notes you take are to refresh your own memory. You should not give additional weight to the comments of any juror based on the quantity or quality of his or her note-taking. These notebooks may only be used in the courtroom or the jury room and may not be taken anywhere else. To identify your notebook, please write your name on the inside of it. No one else will read your notes, and at the end of the case, these notes will be returned to the court and they will be destroyed. During the course of the trial, I may ask a question of a witness. If I do, that does not indicate in any way that I have an opinion about the facts in the case. My questions are intended only to clarify the testimony. The answers that witnesses give to my questions are, therefore, of no greater value or weight than any other answer that may be given. Now that you have been selected to be jurors, there are rules that you must follow. These are the same rules that jurors have always had to follow, and that is because during the trial, this courtroom is a place partially isolated from the outside world. Your decision must be made inside of this place, and you must follow its rules. You must decide this case based on only the evidence and the law presented in the courtroom. You must avoid any other information about the case from any other source. These rules are designed to make sure that there is a fair trial. There are two basic rules. You must not communicate with others or among yourselves about the trial as it is going on, and you must not do any independent investigation or research about the case. I will go over these rules in detail because they are very important, and I'll also explain to you the reasons for these rules. If you learn anyone has violated these rules, you must report that to me or my staff at once. You must not discuss this case among yourselves in any way during the course of the trial. You may not discuss the case among yourselves until after you have heard all of the evidence and you begin to deliberate on a verdict. In fairness, you must keep an open mind throughout the trial, and you should reach your decision only during your deliberations at the end of the trial. Do not permit anyone else to discuss the case with you or near you. If anyone, including one of your fellow jurors, attempts to do so, please report that fact to me immediately. Do not talk with any witness or with the defendant or with any of the attorneys in the case. You cannot talk to them, and they cannot talk to you even casually. Do not communicate about the case with anyone in any way, including in person, by telephone, cell phone, iPhone, the computer, an iPad, the internet, or any internet service. This means you must not email, text, instant message, tweet, or post information about this case or about your experience as a juror on this case on any website or app such as Facebook, Snapchat, TikTok, Reddit, or any similar app or site. You must not read, review, or accept any communications in any form from anyone regarding this case or cases like this. You are permitted, however, to explain to family, friends, and employers that you are on a jury and to inform them of how long the trial will last. You cannot say anything else about any aspect of your experience until you are released from jury service. While each of you want as much information as possible before deciding the case, you cannot be investigators outside the courtroom. Attempting to get further information outside the courtroom would be unfair to the parties and would be a direct and serious violation of your oath. Do not attempt to gather any information on your own. Do not read or research about this case or this kind of case from any other source, including the internet. Many of us routinely use the internet to research topics of interest, but you may not do that in this case. You may not use Google, Bing, or any other type of internet search engine to learn about any person, place, or thing that is involved in this case. This includes the defendant, the attorneys, the witnesses, your fellow jurors, and the court personnel. This applies whether you are here, at home, or anywhere else. Do not read about this case in the newspapers or on the internet, or listen to any radio or television broadcasts about the trial. The law even prohibits you from consulting a dictionary. Do not attempt to visit any places mentioned in this case. And finally, do not in any other way try to learn about this case or this kind of case outside of the courtroom. You may ask yourself, why aren't you allowed to do these things? Evidence presented to a jury in court must meet at least 3 legal standards. First, it must be allowable under the rules of evidence. The rules of evidence are designed to eliminate information that is not reasonably reliable. Second, in a courtroom, witnesses are placed under oath to tell the truth under penalty of perjury. A witness who lies can be prosecuted and sentenced to jail. Third, all witnesses' testimony is subject to cross-examination, which means questioning by the other side. Cross-examination can help you determine whether testimony is credible or evidence is reliable. By contrast, information that you might obtain on your own would not have been subject to the rules of evidence, would not be under oath, and would not have been cross-examined. Therefore, it may not be credible or reliable. Furthermore, if you secretly obtain information on your own, the prosecution and the defense would not know that you had done this, and they would not have a fair opportunity to show that such information may be false, inaccurate, or incomplete. Trials must not be decided based on secret information. Breaking any of these rules would violate your oath as a juror and would subject you to punishment for contempt of court. If you violate any of these rules, you and your fellow jurors might have to come back to court after this trial to testify about your conduct. Furthermore, violating your oath could require a new trial before a new jury. Your misconduct would have wasted all the time that you, your fellow jurors, the court, the attorneys, and the parties have spent in this trial. After this trial is over and you have been discharged as jurors, you'll be free to discuss any aspect of this case with anyone, and you may do any research that you like. But no such communication with others or research about this case may occur until then. We are all depending upon you to uphold the oath that you have taken to follow the rules as jurors, and I am confident that you will do so. With that, I will turn it over to the state to present their opening statement. Mr. Varela, you may deliver your opening statement at this time.
Good morning. You're here because what she did. You're here because of what she did on October 3rd, 2021. And ladies and gentlemen, you're going to hear a lot of facts. You're going to be asked to use your reason and your common sense to filter through it and render a just verdict. And you're all equipped to do that. But there's a famous quote that will help in that process, help in your process. And that's, let us take things as we find them. Let us not attempt to distort them into what they are not. We cannot make facts. All our wishing cannot change them. We must use them. And you will use the facts. And the facts are that on October 3rd, 2021, Christopher Dickerson was viciously and violently murdered in an unnecessary and unjustifiable way. And you're going to hear that law enforcement was dispatched to his home that he had purchased earlier that year by his neighbors, as they called, afraid that he was there, afraid that he was inside. And you're going to see the response from police as they get on scene. This is Officer Flores, Greeley PD. Is anyone in there? That answer is a resounding yes. That person that was in there is why we're here. That person that was in there was Christopher Dickerson. He was a son. He was a friend to many.
Objection, invoking sympathy.
All right, the court will overrule the objection.
He was a colleague. He loved animals. He loved his dog.
Renewing our objection.
All right, Mr. Praley, if you'll move on, please.
And his life, taken by her hands, is why we are here. And ladies and gentlemen, the way his life was taken is going to be tough for you to see.
Objection invoking sympathy.
All right, the court will I'm sorry, did you get a record of that, Cheryl? Okay, the court will overrule the objection.
But it's the way it was. It's the way it is. And you're going to hear that Christopher Dickerson was burnt beyond recognition. He was burnt so badly that he had to be identified in part by his dental records. But ladies and gentlemen, it's not as it first seems. Because Christopher Dickerson on October 3rd, 2021, was not killed by that fire. He was killed by a process of vicious and violent force. And you'll hear on the autopsy that it was noted that there was a particular thing coming out of his neck. And ladies and gentlemen, you're going to hear that that was a metal file. You're going to get to see it. And it had a handle on it. And you're going to get to see that the pointy part sticking out would be where the handle was.
Objection. Facts not in evidence. Can we approach?
Sure.
May I proceed?
Yes, please.
And so the pointy part sticking out of Mr. Dickerson's neck, you'll hear in regards to a likely handle that had broken off or burnt off. And that the blunt part of this file was plunged into the victim's neck not once. What you're looking at would have been the last one. It stayed in his neck. It's the only thing that makes sense. But what you'll hear from Dr. Burson, an objective pathologist or county coroner, is that he notes there are 5 separate and distinct stab wounds in Chris's neck. And you will be asked to consider that using reason and common sense. Plunging a piece of metal with such force into a neck and taking it out. Into the neck and taking it out. Back in, back out, back in, back out, back in. All in the neck region. All in a place directed at a person where you know there are arteries trying to kill. And you'll hear specifically through Dr. Burson that the carotid artery was hit. And that will be depicted by Dr. Burson. And he will opine what that would mean and how that's a bloodletting process and how much blood that would take and the coagulation in that area and the trauma. And you'll get to see the object, and the blunt end is what's going in his neck. And you'll get to think about that using reason and common sense when you're deciding murder in the first degree. And you're to consider all the evidence in light of your observations and experience in life. That's why you were selected. Now, a lot of this is not going to be a difficult decision as to me meeting my elements for you at all. And so we're going to go through that very quickly. But I, again, have to prove that the defendant in the state of Colorado at or about the date and place charge of October 3rd. We'll talk about the mental state of after deliberation and intent and how that corresponds with self-defense, and specifically causing the death of Christopher Dickerson. And Dr. Burson will testify for you extensively. 5 stab wounds. 5 distinct stab wounds. He will opine that the cause of death was sharp force injuries to the neck, and that the manner of death was homicide. Now keep in mind, this autopsy takes place a day or two after they discover Chris being burnt that severely. Nearly 100% of his body is burnt. But you're going to get the whole picture in this case, the totality of the circumstances, the facts that you need to determine what a person was thinking when they were acting. Not just then, but total. That's going to be your job. And ladies and gentlemen, you're going to get to compare that if and when you receive self-defense, and you're going to get to think, is that reasonable? Is that necessary? Does that make sense? Those will be the questions you are asking of yourself and others, particularly as to her actions on that day. So immediately after, Chris is stabbed 5 times in a close region in his neck. You'll get to hear what happened after. And to be very clear, the investigation took a different path, which I'm going to get into for you, as to how we get here, so that you understand why we're here today specifically with her. Okay? And so what you're going to hear is that when officers got to that residence after that fire and pull Chris's burnt body out, there's a lot of things that start making very little sense. And specifically, they go to the bedroom. And they see all these things laid out on a bed. You will get to decide if you think Chris lived that way or not. Okay? Well, what you'll get to see is that there's a particular item, a jewelry box, opened on the bed from Zales. And you'll get to see when those items are taken away, this void. You'll hear from experts in fire describing that, well, it's pretty obvious when you look at this picture, you can tell what was there at the time the fire was started and what wasn't, based on the different coloring. And that's October 3rd. That's what they notice. And so shortly around that time, the victim's father, Alan Dickerson, after he's notified about his son, and after being introduced to the Greeley Police Department, that they're investigating these circumstances, being introduced to Mr. Burroughs, Alan Dickerson starts providing assistance right away. And specifically, he helps him as a power of attorney for his son, helping with bank records, phone number, phone records, and Google location records. And you'll hear a lot about the Google location records. You'll hear from a lot of people that are much more tech savvy than probably you could imagine about your phones track a lot of things.
I'm sorry.
Objection, bolstering.
All right, the court will overrule the objection.
People who specialize in technology are going to come in and talk about if you have an Android device that's connected to Google, you might be sharing your location at a lot of places. Maybe you know that, maybe you don't. But all those things are provided, and specifically Alan Dickerson goes into his son's account. He downloads those records and those locations, and he provides them to Detective Burroughs. What does Detective Burroughs do? He starts following all of those things. He starts tracking movement. He starts ordering records. He starts obtaining surveillance, bank records, places, locations, movement of travel, all these things. Lots of sleepless nights. And what you're going to hear is that he's able to see that Chris, on that night, goes out to the bars downtown, right across the street. And you'll see Chris on the left, and you'll see him talking to a female who's later identified as Dolores V. Hill. And you'll see that she's discussing a phone, and there's going to be cameras at these places with times during these places, and he's using all of these things in conjunction with each other to figure out his location, his activities, and what he's doing, right? And so, for example, in People's Exhibit 81, you're going to hear that at the time of this exchange that's on camera, where there's this number that Investigator Burroughs, or Detective Burroughs, I apologize, that he's looking at the phone records, the movement, the surveillance, and he's able to see, okay, Chris and Dolores, their phones are connecting. He's able to say that I see him on camera, and he's able to track him and what he's doing, his movement. And ultimately, he follows him around downtown Greeley, and he sees Chris leaving on People's Exhibit 88. And he's looking for clues. And he sees this interaction from surveillance on People's 88. Now there's video. Not all video is going to be published. But there's this interaction with this silver Malibu and these distinct rims. And he sees this, and he puts that among things to look into. And he goes through all the other surveillance. And he then tracks back, who are those people in the silver Malibu? What do they look like? What's that car? All those types of things. And when he tracks all the way back, it comes to two people, two females. And he goes through this process, and he's able to say that the defendant is wearing the black. She's got this visor on. She's got her hair up in a bun. And this other individual is Hosanna Varela. And again, that process takes a lot of time of figuring out their specific names. But he knows that these individuals, based on their movement, are associated with that Malibu and that encounter that we just saw. And so what Detective Burroughs does is he keeps looking. And he sees that after this encounter, and after identifying those people, that Chris is heading home. We're walking away from the bars. And you'll get to see, maybe you recognize this, maybe you don't. It's going to be the window at the Rio right across the street. And you'll see Chris walk by it in Exhibit 90. And then right after that, you'll see that in dealing with that, there is a specific vehicle that's shown after Chris had walked by, and it's that Chevy Malibu. And then he's able to obtain surveillance that had been gathered in and around Chris's house on the early morning in question and the night before from 3 different neighbors, and he starts piecing this together, spending hours and hours of viewing this.
Bolstering.
All right, the court will overrule the objection.
And what you're going to hear is that Detective Burrows was able to identify, based on a variety of things and corroborating it along the way, that when he saw Chris walking to his car, ultimately he drives home, he pulls into his garage, and after he gets home, that Chevy Malibu pulls into his driveway. And ultimately they go inside for a while, and you're going to hear, again, at that point, sometime later, that the defendant, Hosanna Varela, and Mr. Dickerson leave. Again, they come to the names of these individuals later. But they leave, and he's able to look at phone records. That Dolores Vigil that you previously saw at the bar exchanging phone numbers, that he goes, he leaves the house, and ultimately they're communicating, and they drive around, and ultimately he comes back. And you'll get to see surveillance footage that, remember, the Malibu had been parked in the driveway. Ultimately, they move it out of the driveway. They're lit up by Chris's brake lights as he's backing out of his driveway. And then you can use the Google location at 254 around 8th Avenue and 11th Street to show where Chris's phone was. The group then returns back to his house. Hours go by. And Detective Burrows, candidly, at that point, does not know what happens in that house other than what Dr. Burson had said.
Objection to this slide 403. Can we approach?
Yes.
So he knows that Chris was stabbed 5 times in the neck, and he continues to watch the surveillance. And what was noted by initial officers, and what was noted by other people who look at this footage, knowing that they're looking at Chris's house and the surrounding area, is that ultimately one person comes out, goes down, and starts the car. And you'll hear from Detective Burrows after watching this multiple times that he notes that, yeah, this door opens. I see this figure consistent with the females. He differentiates from Chris, and he says, I see a female go, walk down, get in the car, but I didn't see 2. And approximately 3 minutes later, go 3 minutes elapse, okay? And then a second figure comes out. Lights to the vehicle are shut off. Figure comes out, slowly, walks down, gets into the passenger side. And they drive away. Calmly. Now, the interesting thing for you is that at that same time that you just saw those two larger females leave that residence and drive away, and that'll be captured on several videos, Chris's phone leaves too. The two females leave and drive away, and Chris's phone leaves. And ladies and gentlemen, you're going to get to hear about those locations. And you'll get to use that in conjunction with Dr. Burson's testimony. Chris didn't die of being burnt. He died by being stabbed 5 times. So there's no way that at that point, he's just giving his phone to people he had just met that night. Because that's what will come out. Chris did not know these girls. He had met them in that alley. They had gone back to his place. They had taken his life. They had taken his ring. They had taken his phone, and they leave. And that will form the basis for the burglary. The initial burglary is for the theft of his phone, of the ring, and other items. But there's more. There's more. There's burglary that deals with arson and tampering with Chris's deceased body. And what you're going to hear is that after leaving at 5:12, they drive around for a period of time, and they return. And when they return, they pull back into the neighborhood, pull outside of Chris's house. One individual on the passenger side calmly walks in, opens the front door to Mr. Dickerson's residence when he is dead. Does whatever she does for a few minutes and sets the place on fire. You'll see the return. It's a cul-de-sac, by the way. See him park. Slowly walk up. Open the door to a deceased Mr. Dickerson's house without authorization. authorization, without invitation, as he's likely laying there dead, having blood out. And approximately 2 minutes go by. You'll hear that no person was ever observed of getting out of the driver's seat. And 2 minutes later, you're going to see it, look at the window, and then watch the exit. Bright lights, flickering. Opening of the door, calmly walking down, getting into the car, and driving away. And the fire begins to go and go and go. You'll be able to look at those Google records, specifically see that lap, that Chris is on the ground, dead, but Chris's phone has made this lap, has returned to his residence, and leaves at the same time that vehicle leaves and drives off. And ladies and gentlemen, you're going to hear a lot about technology in the city of Greeley, specifically about automatic license plate readers. And you're going to hear that at approximately 541 35th Avenue and 25th Street, that Malibu with the plate AER G95 is seen driving. And that location will matter because that connects all those dots. And that's used as an investigative tool for Detective Burrows. And that Google location that was provided by Mr. Dickerson continues to assist in that it shows that path. And ultimately, at approximately 6:13, looking at all the factors, Detective Burrows says something here based on automatic license plate readers and the path of travel. The car doesn't match anymore. And an automatic license plate reader is what it sounds like. It takes a picture of a person's plate, connects to registration, shows a time frame. It's a photo connected to a database. And so, ultimately, Detective Burrows, who's very familiar with working auto cases, uses the location where he knows there'd be another automatic license plate reader and sees, hey, the timing works for this big Chevy Tahoe, plate CEB P61, and connects all those dots. Runs that registration, comes up with the people, starts looking at the two females that he had dealt with, and figures out who the two suspects are. Stacy Rodriguez, the defendant, and Hosanna Varela. And he continues to connect those dots, and ultimately, it progresses to make an arrest. Now, ladies and gentlemen, I think a lot of the discussion detailed that we're going to be talking about self-defense. And you are to use reason and common sense in guiding you in that. You'll be provided the law. You'll be provided all the circumstances and facts. But you're also going to hear that on October 16th, nearly 2 weeks after this, there's an event that occurs. And keep in mind that these neighbors had been providing videos of what they captured, what they didn't. And you're going to hear that on October 16th at 7:46 a.m. on another ALPR in the 1700 block of 25th Street sees that Malibu. And Detective Burrows will be able to zoom in and opine that based on all the features, the earring, Miss Rodriguez's chin, a particular shirt she was wearing, that it's Miss Rodriguez. And ladies and gentlemen, you'll get to hear that at that same time, the footage that's being captured from those same residences catches that the defendant comes back to the scene of the crime. You'll see Mr. Dickerson's house. You'll see his windows boarded up after being burnt. She pulls right up by where she murdered somebody, stabbing him 5 times. You will get to think about a lot of concepts with self-defense. You're opposed to a lot of hypotheticals. This is reality. You will get the facts. You must use those facts. And ultimately, you'll get to decide how guilt and regret would ever play a factor. If you justifiably saved your own life, would you regret doing that? You're going to hear that on October 30th, 2021, when Detective Burrows writes for a variety of documents and databases, that he gets the defendant's Facebook records. And he begins reading them. And again, at this point, he just has them as suspects. And he discovers this after the fact. Facebook is not quick. He goes through this process that you'll hear about, and he's still doing his investigation, and he orders them so that he captures things at a certain point. And what you're going to hear is that the defendant, on either the 29th or 30th of October, UTC, you'll hear about that, you subtract 6 hours. The defendant writes, "I think that thing I did is getting to me now." Like the guilt and regret. And I can't even talk to nobody about it. Could have talked to him. Could have talked to the Greeley Police Department. Nearly 27 days after Chris was stabbed 5 times. That's what's going to be discovered. The investigation continues. And on November 11th, 2021, the defendant is arrested, as well as Miss Varela. And ladies and gentlemen, if the defendant chooses not to testify, you all swore that you would not use that against her in any way, shape, or form. I trust you with that. But you will hear that she made statements on this date. And she denies it all. So in the text message before, she says, "I can't talk to anybody about this. This regret, this guilt." She had the chance on this day.
Gotcha. So we're working on a case. You mind if I talk to you for a couple minutes about it? Okay. Does this person look familiar? No. Okay. Have you ever seen him before? No. Okay. Okay. Have you ever been to 23 Corrections? 2413 15th Avenue Court, Greeley. It's over off like by 25th Street, 11th Avenue. What's that? Well, it's a house. Okay. She doesn't believe she's ever been to the 2413 15th Avenue Court address. She doesn't know anybody who drives her silver Chevy Malibu. Is that right? Have you ever driven a Chevy Malibu?
Never been to the house, never seen Chris, never driven a Chevy Malibu, doesn't know anybody who does. And then she's told that she's being arrested.
Arson, burglary, and tampering, accessory. Okay. Is there proof of that? Yes.
Her response, after all that time, is there proof of that? And you'll get to factor that into your consideration. Now, ladies and gentlemen, you'll hear again that Hosanna Varela was also arrested on that day, and you'll hear that she provided an interview with her lawyers present. And ladies and gentlemen, she outlines what she saw, what she heard. And you'll hear, confirming what we had from phone records, that they had not met before that point. She didn't know Chris. Stacy didn't know Chris. That's consistent with phone records because we never saw any interaction. That essentially just happened in that they were driving, Chris was walking, there's the discussion of going back to his place for an after party. And so they go back to his place, and he had some beer, he had some vodka. And according to Hosanna Varela, the defendant was giving him vodka while they were taking water, or part water. And you will get to ask yourself why that is, looking at all the circumstances. Why would you be feeding somebody an intoxicating substance that you weren't taking yourself? And make no mistake about it, that there's going to be a lot of blame cast on Christopher Dickerson. He was drunk. Very drunk. That's what his toxicology says. And he'll be blamed for that. And you'll get to decide if this was part of the plan. Hosanna Varela will make it very clear to you she never saw Christopher yielding a weapon. He never threatened to kill them, rape them, anything like that. That she doesn't recall any physical force by Chris. But is certain, no weapon, no threats, I'm going to kill you, nothing. And you'll hear that there was an argument, according to Hosanna, between Christopher Dickerson and the defendant. And ultimately, you're going to hear from Hosanna that according to her, Christopher was pushed. And then at some point, the defendant took a beer bottle over to him and smashed it on him. And that Christopher Dickerson was yelling for them to leave, pleading with them to leave. Ms. Varela will say, and has said, She wasn't afraid that night of being hurt, that they could have left. There wasn't a hypothetical door. There was a real door. There wasn't a hypothetical car. It was theirs. It's parked outside. You'll hear the progression. And you'll hear that Hosanna Varela asked her to stop and leave. And you'll hear during the testimony of her that according to her previous statement, she had seen this object, the murder weapon, at Chris's house that was out, that it looked like a file of sort. She describes it as something that would be like used to sharpen knives. There was a handle. She thought it had white tape, wasn't certain, but she saw it. And ultimately, she put it underneath. But she says there was no need to kill him. There was no need. And yet, Stacy Rodriguez did. She'll describe what that sounded like. She'll talk about seeing Chris bleeding out. Describes a death gargle. She'll describe that immediately after, Stacy seemed happy about it. And that instead of calling for 911 or anything like that, what was the first thing that Stacy Rodriguez started doing? She started going through his stuff. Opening cupboards, going into his room. So ladies and gentlemen, ultimately, you'll get the law as instructed in the end, and you will get to determine whether or not you believe it was reasonable. And was there a need for this imminent use of force to defend herself with no weapon, and that had to occur right then when a person was yelling to get out of my house? A reasonable belief, in order to have justified self-defense, you have to reasonably believe lesser force is just not going to cut it in this circumstance. You will get to determine those items as to what was reasonable, what was necessary, and what was appropriate. And there had to be this reasonable belief that there's imminent danger of being killed or receiving this injury. You'll hear the progression that the defendant asked her. In this progression, after the beer bottles, go get the weapon. You'll get to think about that. Deliberate, intentional action of asking for that. And Hosanna did. She'll detail all of that for you. What she heard, what she saw, and you'll hear, according to Hosanna, that then the defendant was moved. You'll hear that she was told to go out and start the car. The video will corroborate that. She discussed that items were taken. She will discuss driving off and then returning, staying in the car, and that the fire was lit. And ladies and gentlemen, they will blame her for all of this. Taking a deal with the devil. For witnessing this horrific murder. Receiving 32 years in the Department of Corrections. You'll get to decide who was the initial aggressor. Hearing that testimony. Looking at the testimony, the actions after, the evidence of flight, and the defendant's multiple statements multiple statements after the fact. And you'll get to compare what those statements looked like between those two girls. And you had been told that they were arrested. And while at jail, you'll hear that Hosanna got a note written on a paper towel. And I know it might be hard for you to see. You'll get this exhibit, but I'll read it to you. I hope you kept the same story. You ain't dumb. I know they gonna trick you, but if you ain't see or do or hear anything, you're cool. You know, don't give in to they shit. Hang in there, babe. You'll be out soon. I just need to see how not to dig myself deeper. I know it's baby Joker's fault. It probably crossed your mind to say stuff, but then you going down too. Don't be stupid. Play dumb. It's all good, Turbo Muffler. LOL. You'll hear that in reference to this, I know it's baby Joker's fault, that that's what the defendant calls herself. When she's referring to her as babe, you'll get to hear about Stacy and Hosanna's relationship. You'll get to hear that Hosanna had previously been in a relationship with a man she had 3 children with, and that the fire just wasn't there anymore in that relationship. And that Hosanna and Stacy had worked together, and Stacy was showing her all of this attention that was missing from her husband at home. And at a certain point, that relationship became sexual. You'll hear on that video when they're arrested, do you know, how do you guys know each other? Yeah, we're definitely more than friends. Would you call yourself a couple? Yeah, yeah. And you'll hear the messages between them. Hang in there, babe. You'll be out soon. I know it's baby Joker's fault. The same person that writes at the bottom of that letter, provided in jail, to flush. That's what the evidence will be. And ladies and gentlemen, you'll hear that was not justifiable, that was not reasonable, that was not necessary. It was vicious, it was violent. And at the end of the day, ladies and gentlemen, you will know that Chris's death, his death in that living room, was only first-degree murder, followed by burglary, by stealing his stuff, followed by burglary for arson, and tampering with a deceased body. And I trust that after using all your reason, all your common sense, those will be the verdicts that you render. Thank you.
All right, thank you. Ladies and gentlemen, we're going to go ahead and take our morning recess at this time. I want to remind you that until the trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, or you see or hear anything about it, even accidentally, please let me know about it immediately. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. If there has been or is any news coverage of this case, you must completely disregard it. Your verdict must be based solely on the evidence presented in the courtroom and the law as I instruct you. And finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of trial.
That's what this is actually about. And we talked about this a lot in jury selection. You were asked about drastic measures somebody might take in covering up something that was justified. And you all were asked, how would that make you feel? What does that make you feel about the justified act? And overwhelmingly, the consensus was people do things when they're panicked. That those drastic measures do not negate a justified action. But what they are drastic measures that were taken in a moment of panic, in a moment of under pressure, resulting from a trauma. That's what this is. And sometimes the pressure of a situation can be so insurmountable that nobody knows how to deal with it. Doesn't mean that actions are correct. Doesn't mean that one person in the same position might have acted the same way. Of course not. But sometimes the worst thing happens and a drastic measure is taken out of pure panic. So over the next week, you're going to hear that Ms. Rodriguez acted under pressure. Stacy, she reacted to a situation that she was presented with. She reacted in a way that was reasonable in the circumstances that she faced to defend herself, to defend the woman that she loved, to make sure that nothing happened to them. Protecting yourself, first response. You're going to hear that about 8 months later, from October 3rd, 2021, so we're looking in June, Ms. Varela, also, Hosanna, she acted under pressure. And she made a decision to save herself as well. And that context of what happened then is when she spoke with Detective Burrows on June 8th, 2022, and that proffer that Mr. Perelia had mentioned to you all earlier this morning. And then we also have the Greeley Police Department, and then of course, subsequently, the prosecution also acting under pressure, making a decision based on the limited information that they have and reacting to that. And they did that when they decided to take what Hosanna told them on June 8th as fact, as capital T truth, as that must have been what happened on October 3rd, 2021. I want to start off by providing you all with a little bit of context of who these people are, of the situation, of the relationships at the time. And so the prosecution had kind of alluded to this a little bit, that Stacy and Hosanna were together. They were seeing each other. But also, Hosanna was married to her high school sweetheart and had 3 children that are young. And so Stacy is 19 years old in 2021. Hosanna's 23. 4 years might not seem like a big age gap. But when you're that age and you're experiencing life at that age, those 4 years can be a pretty big gap. So Stacy, 19 years old, is living with her family. She's very close with her brothers and her mom. That's her life. Hosanna is older, right? She's 23. She's married with children. That's the life she's living. So they get together. They met at work, kind of like how we all meet people. Started as a friendship, and then ultimately gets intimate. They developed feelings. But then when they start dating and when they're together and they're experiencing this relationship together, Hosanna has to balance the fact that she's not divorcing, or she's not leaving, she's not separating from her high school sweetheart, but she's just trying to balance the two. So Stacy's in love with her and wants to be exclusive with her. Of course. But Ms. Varela is also trying to balance the fact that she's not going to separate from her husband. So naturally, that's going to cause some tension in the relationship. I think that's understandable. So that's kind of the basis of their relationship. That's where we're at right now. When we think about the 4-year age gap and how that might play a part in this, you heard from the prosecution that on October 2nd, Mr. Dickerson was out at bars, and they had all met in the back of an alley kind of in downtown Greeley. Where this age kind of gap comes into play is the fact that Stacy, she's not legally able to drink. And Hosanna is a drinker. This is what she does. Also okay. But the age difference means that they have to find bars that Stacy's allowed to go in, that are 18 and up, that'll let her drink, where she's not going to get. So Hosanna, and through her relationship with Stacy, is they're figuring out how to make this work, right? Because she is 23 years old and doesn't have those restrictions. Stacy's 19. She's a few years off from that legal age of drinking. So this is the dynamic that they're also having to deal with. That's when those age differences do matter in a situation like this. You're going to hear that their relationship moved quickly. They moved in together within months of dating. And mind you, Hosanna is not separating from her husband in any type of official way, is not just exclusively seeing Stacy, but they're living together. This is exclusive. And understandably so, when you're trying to balance these things, the relationship becomes codependent and ultimately quite toxic. So this is the environment that we're in. And think of this when you listen to Miss Varela's proffer. Think of this when you listen to the way that Miss Rodriguez, Stacy, sometimes responds to police officers. So consider their statements, look at the body worn, keep this kind of situation, this environment in mind. The prosecution had said, starting off with a quote, "Let us take things as we find them. Let us not distort them." Contrast that when you listen to Ms. Varela's proffer on June 8th. Facts are distorted. The prosecution's theory relies on distorted facts. So let's talk about what a proffer is, what June 8th, 2022 looks like. Again, during jury selection, Mr. McCormick had asked you all, what does it mean to flip a co-defendant? And somebody had given a quite spot-on definition that said, flipping a co-defendant is if two people are charged in connection with the same crime, one of the parties will turn against their partner in the charges and provide evidence against them or agree to help them out in a case. And so that's exactly what Hosanna did. That was a great definition. And your job is to determine throughout this entire trial the credibility of those statements. And we talked about a little bit in jury selection that you get to determine the credibility, use your your life experiences, common sense, the way people react, the way they're telling their stories, the details that are there, the details that are missing, their body language. So you get to determine that credibility. And that also includes motive. Why is somebody saying the way that the story is? Why are they flipping a co-defendant? So for Ms. Varela, Hosanna, when she speaks with Detective Burrows on June 8th, 2022, she had been in the Weld County Jail for over 7 months, from November 11th, 2021 to June 8th, 2022. She is figuring out how to exist in jail. She is kept by herself more often than not. She's completely isolated. And use your real life experiences and your common sense of what does that do to a person, right? 7 months of panic in jail, looking at what the rest of your life is going to look like, sitting by yourself in a cell for more hours than not, spinning, thoughts are spinning. You're panicked. In jail, you don't have your own clothes. You don't have your own freedom. You don't have your own food. You don't get to walk around when you want. You don't get to call people when you want. And if you do call people, they're listening to your phone calls. Your life has flipped upside down. So for 7 months, that's the situation that Hosanna was in. And not just the jail. She had external pressures as well, because we've talked about her husband. He's not happy with the situation, because now he's out dealing with their 3 children and is solely financially responsible for them, solely emotionally responsible for them. He has all of that burden on himself, and he lets Hosanna know that. He does not let her forget that. So she's dealing with that pressure. Her kid's asking her, where is she? Why isn't she coming home? And he has to deal with that. And you're going to hear that Hosanna, she was worried about that. She was worried about the charges that she was facing, the fact that she was in jail with no opportunity to get out, the reputation that then her family was going to have after this. Those are things that she's worried about. And it's not just because of her husband, but also her sister and her mom. Because you're going to hear that her sister and her mom tell Hosanna over the 7 months that she's in jail that they don't want to share with her grandmother or any other family of what she's actually in jail for, because that's embarrassing. So this is what Hosanna is concerned about, the embarrassment. You're going to hear from an expert later in this trial that will give you a little bit more information of exactly what a proffer is, right? I think that definition was very spot on of somebody says something to get something in return, right? You flip on somebody to benefit yourself. And the prosecution had said that, well, 32 years in prison, that's a long time. It's a very long time. However, that's not the full story. That's distorting the facts. What Ms. Varela did agree to, and you're going to hear what she agreed to, is that, yes, she's serving a prison sentence, but if she comes here and testifies the way that they want her to, maybe it'll get lowered. That's a benefit. So you're going to hear from this expert who's going to tell you in a legal context that when somebody goes in for a proffer, it's not because the idea is just to get the truth out. The idea is that you get something in return. So that's the motive. She's embarrassed. Her family is struggling. It's not about Mr. Dickerson. It's not about the truth. It's about herself. I want you all to pay very close attention to the statements that Hosanna makes. That June 8th, 2022 proffer interview is 7 hours. It was a 7-hour interview. And you're going to hear that the first kind of hour-ish of this, Detective Burrows asked Hosanna, just tell me what happened. Tell me about you and Stacy. What happened on October 2nd? What happened on October 3rd? And Hosanna gives a narrative. She talks. She's got a lot of details. But what is very interesting is that first section of when she is just talking without any questions, without any interjections. Think about what those statements are and then compare them to what you will hear later when Detective Burrows says, okay, I hear what you're saying. Well, let me ask you about this, and let me ask you about this detail, and how do you feel about this? And then her story changes a little bit, and we start getting a lot of details, and a lot of details that are not rooted in reality, details that are distorted, details that make it seem as if we are living in a scary movie, and that is not the case. That is not reality. I will agree that the body worn you saw when officers show up on October 3rd is scary. That is horrible. What happened to Mr. Dickerson is horrible. But that is different. We have to remember logic, okay? So when you hear some details that Ms. Varela says after Detective Burrows is asking her questions, that's when she describes what happened with Mr. Dickerson inside that home, and she says that Stacy stabbed him in the neck, and then afterwards, she licked his blood and said, it's dirty. That her face was glowing, and that Stacy had blood underneath her fingernails for days and then went out in public and did whatever she was going to do and just live her life. We are not in a scary movie. This is reality. And so look at somebody's motive. Think about when these details are being added. They're not added initially. To save herself. The Greeley Police Department relied on what she said on June 8th. And you will hear that after that, there was no corroboration. The prosecution said Detective Burrows put in endless hours, sleepless nights. But you're going to hear everything he didn't do. You're going to hear everything that the Greeley police officers didn't do to try to make sure that what Ms. Varela said was actually true. And think about why they didn't do that. Because what if it didn't corroborate their story? Because prior to Hosanna talking with Detective Burrows on June 8th, 2022, the prosecution and the police department had absolutely no idea what happened in Mr. Dickerson's home on the night of October 2nd into the morning hours of October 3rd. No idea. So Ms. Varela gives them a story, right? Because she's sitting in jail for 7 months, thinking about how she's going to save herself and blame it all on Ms. Rodriguez. But we saw those videos. You can see one person is inside the car waiting. No person is acting alone. So think about that as well. So the prosecution and the Greeley Police Department, they also acted under pressure. because they needed Ms. Varela's story. They needed her to make sure that their timeline, that their theory, that their distorted facts make sense. So Ms. Varela shares a lot of details with Detective Burrows. She says her sister was sent something on October 3rd. She talks about her husband. She talks about her mom. She talks about what her and Stacy do on the 3rd, the days after. Detective Burrows, in all of his hard work and sleepless nights, doesn't do anything about that. He doesn't contact the husband to see what he knows. He doesn't contact the sister to see what she knows. They don't do any follow-ups. And what's even more important is what you will hear is that Detective Burrows does tell Hosanna at one point during that 7-hour interview that he is trying to vet her for honesty. Because that is important. Of course that's important. But did he mean it? You're going to hear from a lot of different officers about the investigation that they did after Ms. Rodriguez and Ms. Varela were arrested on November 11th. You're going to hear from these officers that they searched Ms. Rodriguez's home, that they searched her clothing, they searched her vehicles. Think about who they didn't search, the other person that they didn't pay attention to, because it didn't matter. But when you hear about what they searched and what they found, listen to what the officers tell you why they looked for those things, why they looked for her clothes, why they went to her home, why they looked for certain things in the car and collected certain evidence, because that's important. And then think about all the reasons why they did those things, but then never followed through to see if their hypotheses were correct, never followed through to see if science would back anything. Why? Well, it's not going to fall with this distorted narrative, and so we're not going to do that. Have to keep in mind throughout this trial everybody reacting under pressure and everybody panicking, because I think that explains exactly why we're here. So I want to go back to October 2nd and October 3rd. So we know that Ms. Rodriguez, Stacy, is 19 years old. She's dating a woman who's married with kids, and they're going out having a normal night on October 2nd. They're going out to the bars where they meet Mr. Dickerson in an alleyway. And Mr. Dickerson approaches them and says, you guys looking for an after party? I've got one. Great, no problem, that's normal. So that's what they're hoping they go to when they follow Mr. Dickerson to his home, is for an after party. And then it turns out nobody's there. There's no after party. It's just Mr. Dickerson, and it's Stacy and Hosanna. That's it. So this man, mid-30s, okay, these ages, they're important here, right? Use your life experiences. We're all in different life stages right now, right? Guy in his mid-30s invites this young girl over for an after party. And then you're going to hear what happened inside the home. And pay attention to all the things that the prosecution didn't tell you in opening. The prosecution said there was nothing physical in the house, no physical threats. Mr. Dickerson never did anything. Well, that's not true, because Hosanna tells Detective Burrows the opposite. Hosanna tells Detective Burrows that she was uncomfortable around Mr. Dickerson in her home, that he was grabbing her butt multiple times, and she didn't really feel like she was showing him that she was interested. So Hosanna says she's uncomfortable around him. And then she says that actually, Mr. Dickerson and Stacy were arguing at one point in the night, and he cornered her against a wall. Why didn't they tell you about that? Doesn't fit into the narrative. He corners her against the wall in the home, so much so that Hosanna says, leave her alone, get away from her. And Stacy has to push Mr. Dickerson off of her. There is physical contact in the home. And also, think about what it looked like at that time. You're going to see photos of the house. You're going to be able to kind of get a layout of where the kitchen was to where the living room was, where Mr. Dickerson's body was found. It's a ranch-style home. It's small, no levels. You walk in, it's a living room. A kitchen is right next door. So think about all of that. When you are drinking the entire night, 19 years old, and this man who said there was going to be an after party does not follow through. You are in a stranger's home by yourself, and he is cornering you, towering over you, And that's what Hosanna says. He is over her. She remembers multiple times saying he is over her. And he's taller than Stacy by a lot. The prosecution had brought up the drinking and what Mr. Dickerson's, blood alcohol content was. And you're going to hear about the talk screen that was run by Detective Burson, and you're going to learn all about this when we discuss the autopsy. But keep in mind that Mr. Dickerson's blood alcohol content that night was 0.3. It's about 4 times over the legal limit. And again, he's at his house with his alcohol, asking for an after party. Ms. Rodriguez wasn't trying to poison him or get him so drunk he didn't know what was going on. He's in his mid-30s and invited them over for an after party. That's what's going on. Use your common sense. You saw some autopsy photos, and we talked about that metal file. And the prosecution said that Hosanna's version of events is that after, I guess the prosecution didn't tell you that in opening, but after she pushes Mr. Dickerson away, that somehow they end up in the living room, right? And Hosanna says that Stacy says, "Give me that weapon, give me that file." You'll hear the proffer. You'll hear how it actually goes. But then consider the file. Think about that. When you saw those photos, the sharp end is sticking out. And Hosanna describes the file as looked like it had white tape on the handle, the base of it. And you'll be able to see the file, and you'll be able to see the blunt part that is in Mr. Dickerson's neck is textured. It looks like it's wrapped. And you will get to see the file, and you will get to look for yourself. Does it look like anything is broken off? Does it look like something is rough? Or does it look like it is a metal file that has a sharp end sticking out? So if somebody is reacting, trying to save themselves, think about the way that a weapon would have been used. The sharp end is not in, it's out. Think about it might be dangerous for yourself if you have something sharp in your hand and the sharp end is sticking out and you're defending yourself and you're using the blunt end in. That almost puts you at risk as well. It's not smart, it's not premeditated, it's not with after deliberation, it's not thought out, because she easily could have hurt herself as well. Why wouldn't you use a sharp end? It doesn't make sense. It's a panic decision to protect yourself, to save yourself. And when you look at the house and you look at the photos, you will see that there is a door to the living room, but we talked about that in jury selection. You all agreed there is no duty to retreat. But I do encourage you to look at the layout of the home and consider that if somebody is reacting in a panic and what that would look like and not feeling safe and the close quarters that you are in. Now, we know that the house was burned, right? You saw the body worn in the prosecution's opening of the house, up in flames when GPD officers arrive. And that's a scene that probably nobody wishes to come upon. It is going to invoke emotions. It is sad. There is no way, I think, that you can look at this case and not find that there is an emotional component, because there just is. Somebody died. And 2 people are going to have to live with that for the rest of their lives. That's horrible. But you have to sometimes put that emotion aside and go back to the logic and go back to the elements that the prosecution has to prove and go back to what we talked about in jury selection about those drastic measures. Think about how realistic it is that somebody panics and does something because they don't know what else is going on. And that's what happened. Horrible decisions are made, but it doesn't mean that something wasn't justified. Don't confuse the self-defense in a stranger's home, older than you, taller than you, being aggressive, being touchy, drinking, feeling like you can't get away. All of those things can still be true. So you're going to think about, when you hear about self-defense, when you think about what the legal standards are, reasonableness, right? The objective idea. But it's reasonable in the situation itself, in the context that you're presented with. The prosecution talked about guilt and regret. And of course, there's guilt and regret. Of course. Somebody's life was taken. That's horrible. We talked about this a lot in jury selection. We're all agree murder is wrong, but it can be justified in self-defense. But that doesn't mean that it takes away regret, doesn't mean it takes away guilt, because that's a trauma that somebody has to live with for the rest of their lives. And so, again, I want to go back to this distortion, because you saw a portion of those Facebook messages, but that's not the entire story. And you'll get to hear more of the entire story throughout this trial, okay? Openings are just a snapshot of what the next week is going to entail, okay? But when you think about the guilt and the regret, I want you to go back to, actually what the statements say. It's not just that, I didn't talk to anybody, I should have told people. It's every time I close my eyes, I see him. Hardest part of my life. I don't want to keep going. I feel alone. Those are human reactions, human responses to something horrible that just happened, to something horrible that probably nobody ever in their mind imagines that they would have to do to somebody else. Nobody asked for this. Nobody wants this. Definitely not Ms. Rodriguez. So now she has to live with that. And we talked in jury selection about, what if you don't call the police, right? Does that take away the justification? No. Because you all had said, what if people don't believe you? That's also scary. So think about that. You don't think someone's going to believe you? You're just trying to live your life. There's no situation where somebody would act in self-defense and killing somebody else and then be happy about it. That is not a human reaction. That is not a human response. The guilt, the remorse, the panic, that's a human response. Rodriguez was 19 years old at a stranger's house under a situation she didn't think. Thought there was going to be more people. Thought it was going to be a party. And it went differently. It turned differently. He did corner her. She had to push him away, and it didn't stop. So think about all of that. That is what this case is about. It is about panic decisions, decisions made under pressure, relying on distorted facts that don't make sense to fit a narrative because you need that narrative. They need that narrative. But it doesn't go with logic, and it doesn't go with reason. Ms. Rodriguez, Stacy defended herself. She defended the woman that she loved to try to keep them safe. And that's what she did. She is not guilty of first-degree murder.
All right, thank you, Ms. Trujillo. Mr. McCormick, Mr. Pereira, the state may call their first witness.
Your Honor, at this time, the people call Alan Dickerson.
All right, thank you. Thank you. Mr. Dickerson, if you could mind all the cords and just come over here in front of the witness stand. And sir, before you sit down, if you will, please raise your right hand for me. Sir, do you swear or affirm under penalty of perjury that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth? Thank you, sir. Go ahead and have a seat. And Mr. Dickerson, if I can ask you just to get as close to the microphone as is reasonable. And Mr. Pereira, you may proceed.
Thank you, Your Honor. Good morning, sir.
Good morning.
Will you please introduce yourself to the jury, stating your full name, spelling your last?
My full name is Alan Charles Dickerson. That's Dickerson.
Sir, are you married?
Yes, I am.
To whom?
Elizabeth Ann Dickerson.
Sir, did you have a son?
I have two sons. My oldest son, Christopher Dickerson, deceased, and a younger son.
Sir, as it pertains to your son, Christopher Dickerson, what was his date of birth?
His date of birth was October 9th, 1985.
Sir, I'm going to approach with what's been marked as People's Exhibit 1.
That is my son, Christopher Dickerson, with his beloved pet, Juna, a white German Shepherd, a cat, Ella, and what you don't see in the foreground is a chicken. A chicken. We also have chickens at the house.
Your Honor, at this time, I'd move for the admission of People's Exhibit 1.
Any objection to one from the defense? 403. All right. The court will overrule the objection and admit into evidence States 1.
Sir, can you briefly describe your son, Christopher?
My son, Christopher, is a very...
Objection
was-
403.
And can the parties approach? Witnesses answer can stand.
You may
Yes.
answer. Sir, where did your son, Christopher, live?
My son lived in Greeley at a house that he had purchased.
Objection, hearsay.
All right. I'll overrule the objection.
You may answer, sir.
He lived in Greeley in a house that he had recently purchased.
Was that house at 2413 15th Avenue Court in Greeley, Weld County, Colorado?
Yes, it was.
Hearsay.
All right. I'll overrule the objection.
Sir, approximately when had he purchased that house?
Hearsay.
All right. The court will overrule the objection.
He had
May answer,
purchased the house probably only months before he was taken from us.
Sir, at that time, do you know if your son had any roommates at that house?
Yes, he did.
Going back a little bit in terms of discussing Chris, had he worked at Noosa Yogurt?
Yes, he worked at Noosa Yogurt.
In what capacity, sir?
He was a warehouse manager and shift supervisor.
Sir, I want to ask about some prior relationships to your son of Chris. At one point, did he have a very serious girlfriend named Bethany Cook?
Yes, he did. He was engaged to her.
And because of that, was the information shared that he had purchased an engagement ring?
Yes, he had purchased an engagement ring for her.
Do you know where that was from, sir?
I do. It was purchased from Zales Jewelers.
And was that something you had discussed previously with your son?
No, but I did see the ring, and I did see the receipt for the ring in his bedroom.
Okay. Now, ultimately, sir, did that engagement lead to marriage, or did it stop short of that?
It stopped short of marriage.
Okay. And, sir, to your knowledge, was that ring provided back to him?
Yes, the ring was provided back to him.
Are you confident of that?
Yes, I am.
And had you actually seen that then?
Yes, I had.
Sir, I want to transition to the time period of October 3rd, 2021. Where were you living at that time?
I was living at my primary residence, 710 Pine Drive, Windsor, Colorado.
Did you receive a visitor at the door that morning?
Yes, I did.
Who was that?
It was the coroner and victim assistance people.
Were you informed of a general situation
Yeah.
potentially involving your son?
Yes, I was.
And sir, did you assist with providing dental records or similar records?
Yes, I explained that Chris had a broken arm as a young child that required a steel plate in his arm, and he also regularly had dental visits.
Sir, at a certain point, were you contacted by the Greeley Police Department?
Yes, I was.
And who was the lead detective that contacted you, sir?
The lead detective was Detective Burrows.
You see him in the courtroom, sir?
Yes, he's at the DA's desk.
Now, sir, who was the power of attorney for your son?
I was the power of attorney for my son at that time.
Okay. And sir, how often would you get to see your son, Christopher?
I would see him on a regular basis, probably at least 2 to 3 times a week. We took care of his beloved pet, Juna, a white 7-year-old German Shepherd now. At the time, she was about 4 years old. He would leave her with us because he worked night shifts and long weekends. So we took care of Juna for him while he was not able to provide the attention that she needed.
Would you also speak over the phone or through text communications?
Yes, we would text each other and we would have communications over the phone, both him and my mother, his mother.
Are you very close with Chris?
Yes, I was very close with Chris.
Did you have access to several of his accounts, including bank accounts, phone numbers, phone records, and other?
Yes, I did. I was Chris's power of attorney until the time of his death.
And sir, did you assist in providing that information to Detective Burrows as part of the investigation?
Yes, I did.
Sir, as part of that, did you specifically deal with Google location records and aspects of the Google operating system for Chris?
Yes, I did.
And was that associated specifically with Chris's Google or Gmail email?
Yes, it was.
Sir, were you able to actually view that?
Yes, I was. I was able to see that the phone had moved in location on the day that he was taken from us and murdered until after the fire had started, or shortly after the fire had started, or been reported started. I shared that information with Detective Burrows once I had access to the account.
If I could approach with what's been marked as People's Exhibit 202.
202, go ahead.
Sir, do you recognize People's Exhibit 202?
Yes, I do.
And what is that, sir?
That is a SanDisk USB drive.
And sir, how are you familiar with that?
I use this SanDisk USB drive to provide Detective Burrows with 2 invocations of Google takeout dump of the Android device and zip files to maintain the integrity of that data once it was viewed.
So based on all of those aspects that you just talked about, are you pretty familiar with computers?
Yes, I am.
And you went through that process?
I went through that process.
And is People's Exhibit 202 the actual disk that you provided, or the USB thumb drive that you provided to Detective Burrows?
Yes, it is.
Your Honor, at this time I move for the admission of People's Exhibit 202.
Any objection to 202?
No, that's voir dire.
Sure, go ahead.
Absolutely.
Just have a few questions about this. There is no initial on the itself, right? On the thumb drive itself.
No, there's no identifying marks other than it's a SanDisk, probably a 32 gigabyte drive.
Okay. You had said no identifying marks, so I just want to clarify that a little bit for the jury. There's no such as like a serial number or something on here, correct?
No, but the files that exist on there have hash codes,
Okay.
and I can provide those hash codes
But
that specifically identify the files on the disk as being digital copies.
okay, I appreciate that. Thank you. But looking at this specifically, there's no identifying marks besides the fact that it's a SanDisk thumb drive, correct?
That is correct.
Okay, I'll get this back to you for now. So you're unable to say with actual certainty that that is, as looking at it, the exact same thumb drive that you provided to Detective Burrows, correct?
This drive can be inserted in any PC. We can download a cyclic redundancy check, an MD5 sum, or a HA256 hash code. It will be unique to the files that are stored on my server and are stored in the cloud under an AWS S3 server.
So, Mr. Dickerson, I'm not trying to be confusing. I'm just wondering that specific thumb drive as we're looking at it, not the contents of what you believe to be on there, but just looking at that thumb drive, there's no identifying marks to suggest that that is the specific thumb drive that you gave Detective Burrows, correct?
It is not because it was delivered in a different bag with a label on it, and this went into the evidence chain at the Greeley Police Department and labeled with their markings.
Okay. Your Honor, could we approach, please?
Sure.
Couple more questions, sir.
Yes.
How many thumb drives, SanDisk, did you provide to Detective Burrows?
A single SanDisk.
And you're confident that's the one?
Yes, I am. I have no reason to believe that it's went out of the custody, the chain of custody of the Greeley Police Department since I delivered it.
Objection. I think that's something he's able to, that's speculation.
Sir, just to
All
be
right.
clear,
And I'm sorry, Mr. Fraley, give me just a second. All right. I will overrule the objection as to the part of the answer stating, yes, I am. I will sustain the objection to the remainder of the witness's answer and strike that for the record. Mr. Dickerson, it's really important that you just answer the question specifically that you're asked.
Yes, I believe that to be the sand disk that I provided Detective Burrows.
Let's just take a moment. I've handed you a piece of, I've handed you back the exhibit. I've also handed you the scissors, sir, as well as my computer. If you can just open the packaging with the scissors.
Okay.
It's fair to say you cut in the middle of that exhibit?
Yes, I did. I didn't want to destroy the label.
Okay. If you can take that thumb drive out.
Hopefully your laptop recognizes the drive, and it does.
Okay. You can go ahead and click on that, sir.
What I'm clicking on is a Google directory. I expect to see 4 files on that in that directory. Those are takeout files. They're Google takeout files. They're download.
And Mr. Dickerson, again, it's really important that you just
Okay,
respond to
I'm sorry.
questions.
Yes,
You recognize that?
I certainly do.
Is that exactly what you thought it would be?
It is exactly what I thought it would be in the date. Yes, it is exactly what I thought it
And
would
is
be.
that exactly what you provided?
It is exactly what I provided.
Now I'd move for 202, Your Honor.
Any further objection?
You stand on our previous objection, and then in regard to the contents.
All right, the court will overrule the objection and admit into evidence states 202.
Those are my questions at this time.
All right, thank you. Any cross-examination?
Mr. Dickerson, I just have a few questions for you.
Yes,
You mentioned that Chris was working at NUSA around the time in October, right?
that is correct.
Okay. And he had been fired, to your knowledge, for like a whistleblower kind of complaint?
That is my understanding.
Okay. And is your understanding that he was a little angry about losing his job at that point?
Objection. May we approach?
Sure.
And so, Mr. Dickerson, when Chris was let go, he wasn't working around the time of in October, right? He had been let go prior to October 2nd and 3rd?
Yes, he had been let go prior to that.
Okay. Thank you. I appreciate that. Nothing further.
All right, thank you. Any redirect examination?
No.
All right, thank you. Mr. Dickerson, you can leave the witness stand. You can just leave that stuff there and the state will collect. And again, sir, just make sure you mind all those wires, sir. The state may call their next witness.
Your Honor, at this time, the people call Officer Flores.
All right, thank you. Thank you, sir. If you'll come forward and please stand in front of the witness stand. If you could just make sure you mind those wires when you're coming up. And sir, before you sit down, if you'll come over and raise your right hand for me. Yes. And Mr. Flores, if you'll raise your right hand. Sir, do you swear or affirm under penalty of perjury that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
I do.
All right, go and have a seat. Mr. Praley, you may begin.
Good morning.
Good morning.
Can you please state your full name, spelling your last for the record?
Name Joshua Flores, Flores.
How are you currently employed?
I am currently a police officer for the city of Greeley.
How long, sir?
5 years.
All right, because you're our first officer to testify, can you just generally discuss about the training that goes into becoming a police officer?
Absolutely. Consists of about 4 or 5 months of academy, followed by another 3 months of in-house training, including street work. So probably about 7 to 8 months before we're actually on the street as patrol officers.
And can you describe then what it means to be a patrol officer?
Absolutely. So our duties include just responding to calls for service, investigating allegations of criminal incidents, making arrests based on our findings and investigations.
What is your current position with the Greeley Police Department?
I am currently assigned to patrol as a patrol officer.
And is that the same capacity as you were on October 3rd of 2021?
Yes, sir.
Sir, on October 3rd, 2021, were you dispatched to a 2413 15th Avenue court?
That is correct.
Where is that located in terms of what city?
That is in the southern part of Greeley, central southern part of Greeley.
Is that Weld County, Colorado?
That is correct, yes.
Can you describe the general process of how you receive information from dispatch to actually go to a scene?
Absolutely. So dispatch will air the information to us, that is through the radio. In addition to that, we do have our computers in our vehicles that also provide us additional information.
All right. So fair to say that you don't actually get to hear a 911 call as it's occurring?
That is correct.
You're receiving notes as to where to go and what the situation is?
Correct.
Okay. Sir, we're going to take a moment by stipulation to play the 911 call, but I want to make it clear you didn't actually hear that on the night in question of October 3rd.
That is correct.
Your Honor, by stipulation of the parties, the people are moving to admit and publish People's Exhibit 147 at this time.
And from the defense, is that correct?
Yes.
All right, the court will admit into evidence by stipulation, states 147, and you may publish.
No, there's a pop-up line.
Okay, what's the address?
I can't see that. No, I'm next door.
Okay, what's your house address?
15th Avenue, Portland.
Okay,
Please call that.
what's the work?
I think that's
From the
24,
that's on fire.
it's at 2413.
Mr. Praley, can you pause that and can the parties approach?
I think there's someone in.
Ladies and gentlemen, just give us a second. We're going to try and fix this audio issue.
No, there's a house on fire.
Okay, what's the address?
I can't see the number. I'm next door.
Okay, what's your house address?
2413 16th Avenue Court,
Okay,
City, Colorado.
where's the
I think that
from the address,
24
where's the house that's on fire?
it's at 2413 15th Avenue Court.
Okay,
I think there's someone in there.
okay, what's your phone number in case we get disconnected?
I don't know, man.
Okay,
Apparently, Greeley, Colorado.
okay, I'm trying
At 2413.
97047399047, is that correct?
Yeah,
Okay,
that sounds good. That house is fire. Somebody's in there, I think.
okay, I have this, and just to confirm, is that gonna be a house or an apartment?
If that house is on fire, man,
Okay,
you need to get the firemen here.
they're coming as fast as they can, okay, what makes you think that someone's inside?
Because there's a dog barking and there's a car in this place. Man, you gotta get to the fire department.
Okay.
Please.
They're coming as fast as they can, okay?
Okay.
Just stay on the line with me. Did you go into the
Okay.
house?
Hell no, it's burned like crazy.
Okay.
It's 2413 15th Avenue Court,
I have them
Greeley,
coming.
Colorado.
I have them coming. I have all the information in here. What was your name?
My name's Mike.
Okay, Mike, do you know the people that live there?
I just know Chris. Chris. The guy's name is Chris who lives here.
Okay.
Chris.
I need you to get away from the house to make sure you're at a safe distance, okay?
Yeah. Chris. Dang, damn it.
Do you know what part of the house is on fire, or is it
The
just
whole house,
everywhere?
the whole front of the house is on fire, man. The garage and everything.
Okay.
I hear sirens. I hope that's them coming.
They're coming as fast as they can. Is he the
Okay,
only
I
one that
appreciate
lives there?
I think he is, yeah. Here they come. I see the light. Here's the police.
Okay, and I just need
We-
to, go ahead.
We did try and wake him up. We don't know if there's someone in there or not.
Who is that you're
I
talking
think,
to?
I think Chris is in there, the policeman.
Okay, I'll go ahead and let you go, okay?
Thank you very much.
You're welcome, bye-bye.
Bye.
Sorry about the audio issue, sir. Now you've been able to hear that, but the information you had would be written on a screen.
It would have been written on the screen or aired through dispatch briefly, yes.
What time do you arrive to this location?
By recollection, approximately 5:45 in the morning.
Okay. Can you just generally describe to the jury what your observations were when you got there?
Absolutely. Yeah. So as my partner and I arrived, we saw residents completely engulfed in flames. As we approached, obviously, we did see some neighbors yelling, trying to, I guess, get the attention of the neighbor that was potentially inside. Everything was completely on fire.
And sir, during this time period, can you describe what you're wearing?
Yes, so in addition to my uniform, I am wearing a body-worn camera that captures the general aspect of what I'm looking at.
Sir, I'm going to approach with what's been marked as People's Exhibit 5. Have you been able to watch this today?
I have.
How can you tell that you've been able to watch it?
I have signed and initialed, or I have initialed and dated this.
Is People's Exhibit 5 a fair and accurate copy of your body-worn camera as it pertains to first arriving dealing with the fire?
That is correct.
Your Honor, at this time, I move for the admission of People's Exhibit 5 with permission to publish.
All right, thank you. Any objection from the defense?
Would incorporate our previous record, but just note 403 if the court wants us to approach.
Why don't you go ahead and approach just a I will admit state's motion 5 into the record, and Mr. Pereira, you may publish where appropriate.
Thank you. Sir, to be clear, is there audio in the beginning or does it take some time?
So there's usually about a 30-second buffer period with no audio.
Thank you.
This is Officer Flores, Green Police. Anybody in there? Is anybody in there? We don't know. The dog, we've been trying to get him up for. Who lives there, sir? His name is Chris. I think his car is still in the garage. Yeah.
Okay, sir. Would that have been your body-worn camera for the actual fire portion?
That is correct.
Did you also have other duties that would have taken place then after fire came?
Yeah, the biggest one being scene security, just making sure nobody gets in and out, shouldn't be there, what have you.
Okay. And ultimately, after that scene security happened and the fire was put out, can you describe if a body was discovered?
That is correct. I was made aware that the firefighters did discover a body inside of the residence.
Okay. And ultimately, to your knowledge, when you were on scene, what occurred with that body?
Objection, hearsay.
All right, and Mr. Braley, is this for effect on the listener?
It's personal observation plus effect on the listener.
All right, the court will overrule the objection.
So the body was placed into an ambulance, and I provided security for the ambulance specifically for a short period of time.
So you were actually looking at the body?
Not directly, but obviously as they're loading it up, yes.
Okay. Sir, as part of your duties after that, did you also help conduct a neighborhood canvass?
That is correct. To my recollection, fire investigator Cobb showed up on scene, kind of assumed that role where I was at, and then I started canvassing the area for any footage or witnesses or anything.
Footage or witnesses?
Correct.
And can you just define what a neighborhood canvass means?
Neighborhood canvass, generally we're going door to door, trying to see if anybody heard anything, saw anything, if there's any cameras on any of the premises, and if there are, trying to review footage of any video that may have captured anything that could give us any insight or leads to follow up on.
Okay. Sir, did you conduct that neighborhood canvass at an address of 2436 15th Avenue Court with a homeowner of the name of Barbara Hillis?
That is correct.
All right, sir. And specifically, did you identify that residence of 2436 15th Avenue Court as having surveillance footage?
That is correct. There was a camera on the front of the property.
Okay. Can you generally describe what you did then?
So based on the fact that we did locate a camera, contacting the resident to see if they had footage. In this instance, she did have some video surveillance footage of some vehicles in the area.
Objection, hearsay.
I'm sorry?
Hearsay.
All right, the court will overrule the objection.
After reviewing the footage, that's collected and placed into evidence.
Okay. And so you're actually there on scene like we would have just seen. This would have taken place right after your body-worn camera that we just watched ended.
That is correct.
Okay. And were you actually able to observe certain clips and incidents that night that would have happened just prior to your arrival?
Correct. That is correct.
Was it also capturing the fact of your arrival? Specifically, we saw in the body-worn cam that when you go, there are lights on the top of your vehicles.
Yes, I do recall watching a video of me entering the area from the camera.
Okay. And so you were able to actually see yourself on that footage?
That is correct.
Do you believe that that footage was altered or manipulated in any way based on your observations that night and seeing yourself?
I do not.
Sir, I'm going to approach with what's been marked as Exhibits 2 to A, B, C, and D. Sir, I'm going to start with 2A for you, okay?
Okay.
Do you recognize that, sir?
I do.
What is that?
This will be a clip of the video surveillance footage I watched.
Okay. And would all of these have been from the same address, that 2436 15th Avenue Court?
They would be all from the same resident, yes.
Okay. Your Honor, by stipulation as to 2A?
Ms. Trujillo, Ms. Devereaux, is that correct?
Yes.
All right. By stipulation, the court will admit into evidence 2A, and you may publish when appropriate.
If we could publish 2A? That would be much earlier in the night. Is that fair based on the timestamps?
That is correct.
Have you reviewed other clips dealing with 2A through 2G about the aspects of events that you saw during that time period?
I'm sorry, are you referring to like the couple-hour time frame?
Correct.
That is correct.
And can you just tell the jury, when you were there on scene that night, what were the observations that you had of the video at that time?
From what I recall watching the video, I remember seeing a silver sedan enter and leave the area a few times in the span of a few hours. I think beginning around 2:50 in the morning, approximate time, then they left around that time, came back around 3:17 in the morning. Then again, you see the same vehicle leaving the area again around approximately 5 in the morning, where they return again a half hour later. And then they leave shortly after that again. At approximately 5:45, I do remember that's when we show up on scene.
Okay. And to be very clear, I've referenced we've just published 2A, but was that entire security system and that footage captured after that point?
Yes.
Okay. I'm going to approach just in general with 2. And then also reference that there were other clips of the events that you noted in your report. Is that fair to say, sir?
That is correct.
And so overall, with the entire surveillance that would have been captured on People's Exhibit 2, do you have any concerns if the system was working properly that night?
I do not have any concerns, no.
Okay. Do you believe in that short time period in any way, shape, or form that it was materially altered or adjusted?
I do not.
Your Honor, at this time, I move for the admission of People's Exhibit 2.
Any objection to 2?
Confrontation.
All right. Can the parties approach? The court will admit into evidence states 2, and then Mr. Prele, you may publish the clips. Will you just designate them as you play them?
Your Honor, I think it makes sense to publish them through a different witness
Okay,
at a
that's
different time.
That's fine.
Those are my questions at this time.
All right, thank you. Any cross-examination from the defense? Go ahead, please.
No cross, thank you.
No cross? All right, thank you. Sir, you can leave the witness stand.
Thank you.
All right, the state may call their next witness.
Your Honor, the people call Officer Austin Berkeley.
Okay, thank you. Thank you. Sir, if you can please come forward and before you sit down, raise your right hand for me. Do you swear or affirm under penalty of perjury that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead and have a seat. Mr. Prele, you may begin when you're ready. Officer, can you just make sure you get as close to that microphone as is reasonable?
Yes, Your Honor.
Thank you.
Good afternoon.
Good afternoon.
Thanks for your patience. Will you please introduce yourself to the jury, stating your full name, spelling your last?
Yes, my full name is Austin Berkeley. Last name spelled Burckley.
How are you employed?
I'm employed by the Greeley Police Department as a police officer
How long have you been employed as a police officer with Greeley PD?
since 2021.
Okay. What was your duty on October 3rd, 2021?
My duties were, as a police officer, just taking routine calls, calls for service, investigating any crimes from misdemeanors or petty offenses up to felonies.
Okay. And sir, were you on a specific shift or with a specific partner at that time?
Yes, I was.
And who was that?
The partner was Officer Flores, and the shift was Lates.
And is that the individual that just walked out of the courtroom?
Yes, it was.
Okay. Ultimately, were the both of you dispatched for a fire at 2413 15th Avenue Court in Greeley, Weld County, Colorado?
Yes.
All right. Can you just basically tell us what your observations were at the time?
Upon arrival at the address?
Correct.
As we arrived on scene or at the residence, I noticed big flames coming out of the house, emerging from the windows, just smoke billowing out of the house.
Okay. And sir, were you in full uniform at that time?
Yes, I was.
And does that include being equipped with a body-worn camera?
Yes.
If I could approach with People's Exhibit 6?
6, go ahead.
You recognize that, sir?
Yes, I do.
What is it?
It is a CD that has my body-worn camera footage on it.
And does that pertain to the fire and your response to that address?
Yes.
Is it fair and accurate?
Yes.
Your Honor, at this time, I move for the admission of 6.
All right, thank you. From the defense, any objection?
Incorporate our previous objection.
In D45?
Correct.
All right, thank you. Noting the defendant's objection, I will overrule the objection and admit into evidence State 6, and you may publish where appropriate.
Can the court help me with timing? I know you have an obligation at what time. I don't want to take up more time than I have.
How lengthy is the?
7 to 10 minutes?
We should be fine. We should be fine. Go ahead.
Well, I'll publish it later. Actually, I think that makes sense. Sir, would yours have been very similar to Officer Flores?
Yes.
Okay.
Objection calls for speculation.
I will sustain the objection, Mr. Praley. If you want to ask additional foundation on that, you can.
Were you both wearing a body-worn camera that day?
Yes.
Were you both there?
Yes.
Were you very close to each other?
Yes.
Do you think they would be similar?
Objection calls for speculation.
I'll overrule the objection.
Yes.
Okay. Sir, we've just published Officer Flores in dealing with the fire. Ultimately, the fire department came.
Yes.
Okay. And, sir, what was your role after the fire department came?
My role was to canvass the area for any potential video footage that was captured by the surrounding houses.
Okay. And did you do that?
Yes, I did.
Specifically, did you speak with a neighbor, Joe McDowell, at 2405 15th Avenue Court?
Yes, I did.
Is that in Greeley, Weld County, Colorado?
Yes, it is.
And in speaking with that homeowner in your neighborhood canvas, did you observe whether or not he would have any kind of surveillance system?
Yes, I did.
And what kind of system was that?
It was a Ring doorbell camera.
And sir, as you were there doing that neighborhood canvas, were you able to pull up portions of that?
Yes, I was.
Were you able to watch certain events on that while on scene?
Yes.
Okay. Specifically, were you able to watch events that would have just transpired, such as you guys arriving?
Yes.
Okay. Did you have any concerns about the fairness and the accuracy of that footage in terms of what you were viewing?
No.
Okay. I'm going to approach with what's been marked as People's Exhibit 4.
4, go ahead.
Sir, do you recognize People's Exhibit 4?
Yes, I do.
And how do you recognize it?
Has my initials on it and dated.
Okay. And so you reviewed it in anticipation of your testimony today?
Yes, I did.
And as it pertains to that disk and the files contained on that disk, do you have any concerns that they were materially altered in any way, shape, or form?
No.
Is that specifically the video that you obtained that night from that neighbor at that location?
Yes.
Your Honor, at this time, I move for the admission of People's Exhibit 4.
Any objection to 4?
Confrontation.
All right, the court will overrule the objection and admit into evidence states 4.
Those are my questions at this time.
All right, thank you. Any cross-examination? Go ahead, please.
No cross-examination. Thank you.
All right, thank you. Sir, you can leave the witness stand. Thank you, sir. Mr. Praley, the state may call their next witness.
May we just approach for timing with
Sure.
the court's obligation?
Sure. All right. Mr. Praley, why don't you go ahead and call your next witness?
Your Honor, at this time, the people call Detective Johnny Blair.
All right, thank you. Thank you, sir. If you'll come forward. And before you sit down, if you can, raise your right hand for me. Sir, do you swear or affirm under penalty of perjury that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth? All right, thank you. Go ahead and have a seat. And Mr. Praley, you may begin when you're ready.
Thank you. Good afternoon, sir.
Good afternoon.
Will you please introduce yourself to the jury, spelling your last name?
I'm Detective Johnny Blair with the Greeley Police Department, Blair is Blair.
How are you employed?
Officer with the City of Greeley Police Department, currently assigned to investigations.
Can you describe what it means to be assigned to investigations?
Yeah, as a police officer, you can test to be in a unit more specialized, in this case, investigations, where you are then a detective, either property persons or a gang unit. So right now I'm in the property investigations unit.
Can you outline your experience as a law enforcement officer?
I was with the Weld County Sheriff's Office for 2 years and then got hired by the Greeley Police Department in 2016. So I'm going on my 9th year.
Sir, what capacity were you serving in on October 3rd, 2021?
I was a property detective at that point.
Okay. Can you describe what your role in this case then was?
As a property detective, we handle robberies, burglaries, motor vehicle theft, fraud, and arsons. So I was called in to assist as there was clearly an arson.
Okay.
Objection. Invading the province of the jury.
I'm sorry?
Invading the province of the jury.
All right, I'll overrule the objection.
All right, sir. On October 3rd, 2021, do you actually go to the scene?
Yes, I do.
And can you describe, at that point, did you see a body?
When I arrived, the fire department had already been on scene. So I did eventually see a body that had been discovered in the fire.
And where was that?
It was in the back of an ambulance.
Okay. So it had been moved from the living room in the residence?
Correct.
All right. Did you assist in taking photos at that point?
I did.
Did you also then assist in a neighborhood canvass for surveillance footage?
I did.
And would that have been in conjunction with other members of the Greeley Police Department?
Yes.
Okay. So for example, we've previously admitted People's Exhibit 4, the surveillance footage from 2405 15th Avenue Court. Were you assisting with those ring videos?
Yes, I spoke to several neighbors in the neighborhood.
And several neighbors in that area that had surveillance. Is that fair?
Yes, that's correct.
And during that time as a detective, were you looking at the different vantage points for each of the surveillance systems?
Yes.
Okay. And were you able to see corroboration between the events, for example, the fire and Greeley arriving?
I guess explain that.
Yeah. For example, you know that you arrived at a certain point and the fire department arrived at a certain point. Were you able to look on those videos and see certain events like that occurring?
Oh, yes.
Okay. Sorry, probably a poor question as we're going through the lunch hour here. My bad. You go to several neighbors during that time period. Is that fair to say?
Yes.
And so one of those was Mr. McDowell's that I had discussed at the 2405 address. Was another one at 2406 15th Avenue Court, which would have been Mr. Thomas Taylor's address.
I believe so, yes.
And when you were out there on scene at that time and then later, were you able to actually view those videos there on an iPad?
Yes, I was.
Okay. And were you able to then figure out the time frame in terms of daylight savings time and being 1 hour behind, those types of events?
That is correct.
Okay. Were there certain incidents or events that you saw captured on that surveillance when you were just there on scene initially?
Yes.
That were notable to you?
Yes.
Can you describe those to the jury?
The video on the iPad specifically?
Correct.
So the timeline showed that a vehicle had arrived at the house that had been on fire, and then when it left, the lights were off, which is not typical, and then that...
Objection calls for speculation.
All right, the court will overrule the objection.
You can continue, sir.
So, and then the car, at least same looking car, returned to the scene, and a flash of light, it was seen through the main front window, and then the car leaves again, and the house is seen going up in flames, giving us reason to believe that there was foul play.
Okay. And was all that video captured?
Yes.
And ultimately, from that homeowner, do you go back for videos on October 16th as well?
Yes, I don't know if I physically collected all the video in this case, but I was aware that it was being requested and archived.
Okay. And able to say that it was all captured from that particular residence that we're referring to, that of Mr. Thomas Taylor at 2406 15th Avenue Court?
Yes.
Okay. Did it appear to you in any way that that video had been altered or manipulated as you viewed it?
Not that I knew of, no.
Okay. I'm going to approach with what's been marked as People's Exhibit 3. In general, sir, do you recognize that?
Yes.
Okay. Is that a fair and accurate copy of the incidents and events that you saw not only there on scene, but then later on that disc?
I don't obviously know what this particular disc contains, but yes, this was what evidence was stored on and booked.
Okay. And specifically, there are tag numbers associated with your reports and docking that. Is that fair?
Yes.
And that would correspond to G21-17441?
I believe so.
Okay. And that would have been associated to your report specifically in this case?
Yes.
And you recall actually doing that? Is that fair to say?
Yes.
And you recall viewing that evidence?
I viewed some of the evidence, yes.
Or some of the events?
Yes.
But it was all captured from the same system?
Correct.
Do you have any reason to believe that's not fair and accurate?
No.
Your Honor, at this time I move for the admission of People's Exhibit 3.
Any objection to 3?
Yes. Can we approach?
Yes, please. All right, thank you. I've sustained the objection. And ladies and gentlemen, I think this is a good point to go ahead and break. And ladies and gentlemen, I apologize. I meant to tell you this earlier, but I neglected to do so. I do have some unrelated court business that I need to handle this afternoon that unfortunately is of the nature that I can't get coverage for. So we are going to go ahead and break early today. So I'm going to go ahead and break for the day right now. I want to remind you that until the trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, or if you see or hear anything about it, even accidentally, please let me know about it immediately. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. If there has been or is any news coverage of this case, you must completely disregard it. Your verdict must be based solely on the evidence presented in the courtroom and the laws I instruct you. And finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of trial. With that, we will be in recess for the day. Again, I'll have you report tomorrow morning at 8:30 to the jury room upstairs, and then we'll resume with testimony at that time. Please rise for the jury. you. Please be seated. All right, the court will be in recess until tomorrow morning at 8:30.